Brian Watt, and I'm a partner in the business litigation group with Troutman Sanders in Atlanta. I want to welcome you to the second podcast in a series of podcasts that Troutman Sanders and Pepper Hamilton will be producing over the next few weeks to discuss litigation topics that have been brought to the forefront by the COVID-19 pandemic and how businesses might be able to prepare and respond. Today's podcast is going to focus on liability issues for businesses that remain open during the crisis. We will look at how the stay-at-home orders of various states impact whether a business should stay open and what enforcement actions it may face if it is not an exempt business or does not follow the mitigation measures required of exempt businesses. We will then focus on several employment issues that employers are facing related to the crisis. And next, we will broaden our focus to discuss the types of litigation related to COVID-19 that businesses are already facing, including class action lawsuits. Finally, we will consider some of the steps that a business should follow to reduce liability risks. Our panel today consists of Ashley Hager, a labor and employment partner in Troutman Sanders' Atlanta office, Matt Aaronson, a litigation partner in Troutman's New York office, Brian Downey, a litigation partner in Pepper Hamilton's Harrisburg office, and Will Taylor, a litigation partner in Pepper Hamilton's Boston office. Each of our panelists has extensive experience representing clients in complex litigation matters, and in recent weeks have been advising clients on liability stemming from the COVID-19 crisis. So with that, let me start by asking a question to Matt Aaronson. Matt, how do businesses know whether they can stay open, and if so, to the extent to which they can stay open?
So that question really, depends obviously on the jurisdiction, the state. Pretty much, and I did some checking on this yesterday. Every state, you can go to their state website, and for the most part, they have a link that'll, something that says COVID-19 or someplace you can click, and then you'll scroll through and you'll typically find something for business guidance. And what I've seen is that most states, and obviously I'm in New York, so I've been looking at that for weeks now, but very similar. Most states will have a listing of the types of businesses that are, some states use essential business, other states are using other terminology to describe those businesses, but you'll see a listing for some states. New York actually lists the different industries that you can be a part of, and then you can continue to operate. Other states have the opposite. I was looking at Georgia, and Brian, Ashley, maybe you'll be able to chime in differently. It's a little bit less precise on the information on those states as to what businesses can stay open. What I actually saw was the opposite. It said specifically what businesses cannot stay open, and then it gave more general limitations on businesses that were allowed to stay open, but then they had certain, you had to keep a 6-foot social distancing rule, sanitation rules. So every state has guidance to businesses as to how they should be operating and whether they can operate. The other thing that people should consider doing is if you're a retailer, almost every retail association by industry has put out guidance to their members, and most of that's on their websites. And a lot of them even give you handy state-by-state breakdowns and links. And they've done a lot of that work, the Retail Federation and other organizations, to allow their members to know what states they can operate and what states they can't. But generally, what you're seeing is that obviously healthcare is allowed to operate. Financial institutions, banks, pharmacies, grocery stores, most food providers. Now, what's interesting is some states have declared wine and liquor to be essential businesses. Other states have not, and I know that some of our colleagues at Pepper Hamilton may be disappointed that Pennsylvania has not allowed liquor stores to stay open, which has now caused people to be driving across the border to Ohio, apparently, to go buy alcohol during this time. But it's really state by state. I know North Carolina also has allowed wine and liquor stores to stay open. New York has also. So you have to really, look state by state. Other things, big issue, big question about is restaurants and bars. For the most part, what I've seen, and New York's done this from the beginning, is that they're allowed to stay open for takeout and delivery only. There's no dine-in options. Other businesses, obviously transportation services, including airports, hotels, mass transit. You have obviously infrastructure, utilities, trash collection, all those type of things are typically allowed. The areas where it starts to get a little bit grayer and you have to really check each state are things like manufacturing. And it depends on the type of products that you're manufacturing. And also there's a big one in New York, a catch-all is called warehousing. And I think actually I looked at Pennsylvania has the same thing. I know a lot of businesses will try to say, well, I have a warehouse, I ship goods to customers, therefore I fall within the warehousing exception or permissible essential use. That's an area that I think you really have to be careful about and look at more deeply on a state-by-state basis to make sure that you're not running afoul of that. The other thing that people should do and companies that are staying open is if you're not listed or you are not sure if you're listed, one of the things you can do, at least New York actually has a link on their website which allows you to seek specific permission to be deemed an essential business, even if you're not falling within one of the categories. And in fact, in New York, actually, it's like a verification that you are a business that being designated as essential would be in the best interest of the state. I know from one client that they filled out that form and never heard back, so they don't really know what the answer is, but they at least felt they took the step of filling out the form. They submitted it to the state. So really, again, it's check the state websites, check the retail federations, which really just link you back to the particular orders. And then just sort of on that, that same related note, you have to, again, as I mentioned, places like Georgia have certain requirements about social distancing. Other states like New York have requirements that certain businesses only have a limited number of employees if they are an essential business. Sometimes it's just one person. So like for a convenience store, they can have one employee in there. So really check those things. And one thing that Ashley and I were talking about yesterday was New York, just I think last Friday, required that any essential business that stays open must provide their employees with masks, which obviously becomes a whole problematic issue with the inability to obtain masks. But they did say it's face coverings or masks to allow, I think, some flexibility there. And then the requirement that the employees in those stores wear those masks or face coverings. So I think you're going to see more of that from other states. And that really, goes into the sort of employment area also, but it's an interesting add-on that everybody should be checking and making sure that if they have a requirement that they do that.
Great, thanks, Matt. So you mentioned the state orders that would list either exempt businesses or businesses that are allowed to stay open. If a state order does allow a business to stay open, does it also protect that business from liability from lawsuits brought by the employees or customers?
So not that I've seen so far. I actually have been thinking long and hard about that. I've got questions from clients about that. And the only thing I've seen so far is protections for healthcare providers and manufacturers of PPE, such as masks and gowns. There's talk out there about things like firemen's protections, which basically prevent police officers and firemen from suing equipment manufacturers, but those would not apply, in my opinion, obviously to retailers or other companies who are operating. So right now, I have not seen anything. It may be coming, but right now it seems like you're still going to be subject to whatever ordinary liability you may have if you continue to operate during this time.
Great, thanks, Matt. So let's switch gears a little bit and talk about employers and the issues that they are facing. Ashley, as a labor and employment lawyer, should an employer be worried about liability for claims from employees who are exposed to or who contract the virus at work?
In normal times, when an employee gets ill or injured at work, their usual remedy is that they can file a workers' comp claim. But the interesting thing is that this is completely state by state specific, and a lot of states' workers' comp statutes have an exclusion for the ordinary diseases of life. So, the flu, common cold, that kind of a thing. And there's been a number of commentators who have said that they think that the coronavirus, COVID-19, is going to be fall into that bucket as an ordinary disease of life, so it would not be covered by workers' comp in a lot of states. Some states are starting to make changes to that, with Washington State being the first one to do that, and they've actually changed their workers' comp law to say the COVID-19 disease is a compensable disease. So if it's an occupational illness, workers' comp illness or injury, then the employee is going to be barred from suing the employer, so the employer doesn't have to worry about liability in that context. But if it's not covered, then the employer does have to worry about that more, and because there is a possibility that the employee may try to sue the employer. We've actually seen one big high-profile lawsuit already, which was a wrongful death case that was filed against Walmart. And interestingly, against Walmart and its landlord. The employee is going to have to prove that they contracted the disease at work. And that may be relatively easy for healthcare workers working in a hospital who are exposed all the time. It may be a little bit, not as easy, but still, possible if you have a situation like in the Walmart case, and like we've seen at some of our clients where everybody on a particular production line gets it, so it is pretty likely that they caught it at work and spread it to each other. But I think as the virus becomes more and more widespread, it's going to be tough for an employee to prove that they caught the disease from someone at work as opposed to somebody at the grocery store. The employee is going to have that hurdle, and then in addition, the employee is going to have to show the employer engaged in some sort of reckless or negligent behavior if it's not a workers' comp injury and they're just trying to go after the employer directly for that kind of a claim. So what we've been telling employers to do is that they need to follow the CDC guidance. So instructing employees obviously about social distancing and washing and sneezing and sending folks home if they report an illness or that they're exposed, that sort of thing. So, if you're following the CDC guidance, I think you're taking steps that you'll be able to show you weren't reckless, you weren't negligent. I should also mention that one thing that folks have been worried about is OSHA liability. So, separate and apart from liability to the employees, the concern that OSHA might cite them for some sort of a violation. And again, what we're telling people is if you're following the CDC's rules, you're following the best practices that are out there.
Ashley, let me ask you another question. What obligations do employers have to warn or notify their employees that another one of their coworkers has either contracted the virus or been exposed to the virus?
I'm not aware of any legal obligation that an employer has to inform their employees about that. But I think all of us are still recommending to our clients that they be transparent with folks. And you're doing this for two reasons. One, obviously, is to protect yourself against any potential liability, but also really to build trust with the employees, because obviously it is a really, it's a tough time and folks are suspicious and worried and scared. So, we're telling people, obviously, you don't want to share the names of the people who have informed you that they have come down with the virus or been exposed, but we do think it's important to share details about when that employee was last in the workplace, when they tested positive, or if they've tested positive, or if they've just been tested and are waiting for results, and really importantly, where in the workplace the employee was. So they were on the 33rd floor, they went to the break room, they went to the locker area, whatever those are. I think it's important to give employees that information about the person who has tested so they can make their own conclusions about whether they need to go and seek a test.
Tell me, Ashley, what if the employees hear this information? What if they start resisting coming to work because they're scared of contracting the virus?
Well, I think there's a difference between employees who are concerned about coming to work because they're at risk. They fall into one of those at-risk categories with certain underlying conditions, or they're over a certain age, or they're obese, have diabetes, that kind of thing. And someone who's just nervous without any real reason to be. And I don't say that in a pejorative way. Obviously, it's a scary situation. But, just, again, distinguishing between people who have a medical reason to be concerned and people who don't. And the situation involving people who are in an at-risk category is easier. What we've been telling people is treat it like it's a normal request for a reasonable accommodation for a disability under the Americans with Disabilities Act. So you're going to want to look at, is there a medical reason for the request? Ask for clarification about what exactly they're asking for. Are they asking to stay home? Are they asking to work off of the front lines or in a different job? And then determine whether you can reasonably accommodate that request without it causing an undue hardship. So it may involve assigning people to not work with the public or to let them go on an unpaid leave. And by the way, I don't think there's any requirement that you pay people who say that they don't want to work for this reason, unless there's something required by state law. So that's for the at-risk, people in an at-risk category. I think for other employees, it really depends on how much you need those workers. If you can get by without them, I think this is the time to let folks stay home on an unpaid leave. But if you're an essential business and you're doing everything you can to keep the business running, keep the workplace clean and safe, and somebody still says, I just don't want to work, I think you can hold them accountable, and you can discipline them if necessary. It's obviously not a popular decision. You have to worry about the morale effects on the workforce, but I think you can. And I've talked to one client who actually tried to take the opposite approach and not use the stick, but use the carrot. And they've been offering employees a bonus, effectively like hazard pay for coming to work. But that's created its own set of issues. And namely, you're paying people to do their regular job. And you're also incenting people to come into work when they're sick, if you're offering a bonus, if they do. So, my preference is to really just try to be understanding and obviously follow your accommodation requests. But beyond that, people need to work.
What issues should an employer be thinking about if they're considering taking employees' temperatures to determine whether they should be permitted to work?
I think there's a lot of privacy risks and negligence risks. So, things to think about are if you're going to do the test, who's going to do the test? Can you get a third party to do it? Kind of hard to find nurses and medical personnel right now, but could you do that? If you're going to have folks in your workforce doing it, have they been trained? Need to make sure they're trained if they're not already. Can you get them PPE to protect them? Because I'm worried about claims from those people who are coming into contact with a lot of potentially sick people, and they have to be close to do the within the 6 feet to do the temperature test. So you want to think about the health and safety of the person administering the test. You want to think about employee privacy for the people being tested. You may consider trying to find a way to do those tests in a private area, so not in front of everybody right as they walk into the facility. And I have one client who's providing the test back to people, the test results back in writing. They're giving them a written piece of paper that says, we tested you and here's your temperature, and do with it what you will, but you can't come into work for the next 2 weeks until you have a clean test and so forth. So think about doing confirmation tests. And think about pay. If you have folks lining up to start their shift at 9 a.m. and they have to stand in line for 15 minutes or get there 15 minutes early to get through the line, you're going to need to pay non-exempt employees for that time. And then, of course, what are you going to do with the people who test positive? There's no point in doing these tests if you're not going to be taking some employment action based on that. So you probably want to check the CDC guidelines for what do you do with workers who have been exposed or who test positive, and just follow those.
So Ashley, you mentioned already that we've seen some litigation. I think you mentioned the wrongful death lawsuit against Walmart and its landlord. Let me ask Will, have you seen similar lawsuits arising out of the COVID-19 pandemic? And if so, what can we learn from these lawsuits?
Yeah, absolutely, Brian. We're seeing a really wide range of litigation emerging from the COVID-19 crisis. There's so much, in fact, that we're going to break it into sort of two buckets. I'll talk about individual lawsuits or lawsuits brought by individuals, and Brian Downey will follow to describe the sort of cases we're seeing in the class action arena. So I'm going to focus on three types of civil litigation that we're seeing related to COVID-19. I'll pick up first on the negligence suit, since Ashley already raised that. We are already seeing negligence lawsuits against businesses by employees and by customers, alleging that the employer and or the company at issue is not making the workplace, or in one case it was a cruise line, not making the cruise safe enough for the patrons. The wrongful death lawsuit that Ashley raised was filed in Illinois. The employee was a member or an employee of a nationwide grocery and retail chain. He passed away. Another employee at the same location passed away a few days later. So the employee number one has sued already, or his estate has, alleging that the employer knew that the work site was not safe because it knew that certain other employees were showing symptoms, and that it didn't do enough to follow the mitigation measures like sanitizing and social distancing. As Ashley already pointed out, the estate also sued the commercial landlord in which the specific store was located, and said that the landlord should have known that in the pandemic circumstances that it was unsafe to keep the retail site open and should have shut down. So we'll be following that to see what it does in the negligence arena. Also, as already mentioned, passengers on a cruise ship have sued the cruise line, saying that the cruise line knew that certain passengers who were on the previous voyage had showed signs of the illness, and they had disembarked, and the cruise line should have either shut the subsequent cruise down entirely, or should have cleared out all passengers and followed the right sanitation procedures, which it didn't do. So we'll also follow that one. I'll say my takeaway from the negligence cases is that this is not a matter of whether there will be negligence lawsuits. It's more that how massive will the onslaught of negligence cases be. As of the morning of April 15, 2020, there are nearly 30,000 reported deaths related to COVID-19. So to think that there'll be just a handful of negligence lawsuits would be a mistake, in my opinion. So that's one trend we're seeing. Another trend we're seeing is litigation by businesses against other businesses that are allegedly engaging in improper practices related to the supply of COVID-19 tests and products used to combat the spread of the disease. One example in California federal court is the manufacturer of those N95 respirators sued a supplier of PPE to hospitals and healthcare providers. The manufacturer contends that the supplier is seeking to exploit the increased demand for the respirators by offering to sell them at extremely high prices, selling counterfeit versions of them, and accepting money for the respirators with having no intention and or ability to sell them. The legal theory there is trademark, unfair competition, and false advertising. Similarly, in Florida federal court, a manufacturer of COVID-19 tests has sued a company and its principals for falsely and deceptively advertising and offering for sale the manufacturer's COVID-19 tests, when it in fact had none of those tests and had no relationship whatsoever with the manufacturer. Those claims are also brought under federal trademark law and Florida's deceptive trade practices statute. I'll mention, while outside of civil litigation, it's also notable that federal and state authorities are closely watching the conduct of suppliers of PPE products and other scarce products to make sure that there's no price gouging and hoarding. I think just yesterday, some of the Virginia's top prosecutors have announced a task force to specifically focus on that conduct. The takeaway here is that both manufacturers of PPE and other products used in the fight against COVID-19 should be aware of and should guard against the sorts of misconduct alleged in these cases. At the same time, suppliers of these types of products should confirm the accuracy of their claims about the source and availability of PPE products and the like. The last trend I'll mention is that there is litigation against buyers that have used the negative impacts of the COVID-19 crisis as a basis to pull out of pending mergers and acquisitions. You may have seen these cases referred to as MAE litigation, which refers to material adverse effect clauses that are in the contracts between the buyer and seller in the merger and acquisition context. To really oversimplify it, an MAE clause, or a typical one, typically allows a buyer to terminate a pending M&A transaction upon the occurrence of certain types of developments that negatively impact the target company. There's been several litigations already, several in Delaware, and then also one recently filed in Texas federal court, where a target company alleges that a buyer decided not to close on the acquisition of a company upon the contention that it was not obligated to do so in light of COVID-19 related fallout. The buyer allegedly claimed that it was unable to perform certain conditions to closing and was excused from doing so pursuant to certain defenses to performance. These are common law defenses like impossibility, impracticability, illegality, frustration of purpose, and commercial frustration. Notably, the contract between the parties did have an MAE clause, and it specifically excluded epidemics, pandemics, and outbreaks as events that excuse the closing of the transaction. The seller filed suit and seeks injunctive relief requiring the buyer to close the transaction. The seller argues that the inclusion of the epidemics, pandemics, and outbreaks in the MAE clause prohibits the buyer from relying on such occurrences to excuse the failure of a closing condition. The takeaway here is that this case and other MAE-related litigation pending in Delaware show that some target companies are willing to sue to enforce transactions that they believe should close despite the impacts of COVID-19. These litigations are proceeding on fast-track schedules and may result in law that impacts pending merger and acquisition transactions.
Great, thanks, Will. And I will add to what Will just discussed about these lawsuits, the negligence-based lawsuits that we, in the real estate litigation group that I'm a part of, we're seeing a lot of commercial tenants invoking force majeure clauses, impossibility of performance arguments in an effort to excuse their performance under commercial leases. Whether those arguments have any merit or are ultimately validated in litigation, that remains to be seen. But in the short term, I think we will see a lot of commercial landlords and tenants trying to work something out, trying to work some sort of arrangement between them, whether that's a period of rent deferral or abatement for a short period of time, or perhaps a negotiated lease termination agreement. But one thing is clear, this is a common concern for both landlords, commercial landlords, and commercial tenants. And I expect to see a lot of activity, a lot of litigation in this area in the coming months. Brian Downey, Will mentioned that you were going to speak to the class action litigation that we're seeing. What can you tell us about that?
Yes, thanks. We are seeing class action litigation across the country now, and I expect that trend to continue. So I'll talk about both what we are seeing now and then what we might expect to see in the not too distant future. As we move through each phase of dealing with and responding to this pandemic, what we're going to see are new and different types of plaintiffs, both individual plaintiffs and corporate plaintiffs, asserting a variety of theories in the class context to address what they perceive to be injuries that they have suffered either from the virus itself or from the response to that virus. And I think this evolution of claims is going to require businesses that are responding to the immediate COVID-related crisis, often in real time, to be thinking through not only how best to address the fire that is in front of them right now, but what are the wider implications of every decision to identify who might be the potential plaintiff claiming to be aggrieved by their decision or group of plaintiffs, and then how best to take steps now to minimize that risk. Just at the risk of oversimplification, if we think of a class action litigation really is a vehicle that permits a group of plaintiffs who claim to have suffered the same injury as the result of the same conduct by the same defendant to bundle those claims together and litigate them in a single action. And given the national implications of COVID-19 and the current pandemic and the both statewide and nationwide responses that are being developed to it, it's not surprising that plaintiffs are seeing themselves as part of a group that is being affected similarly, and therefore that they have similar claims which are best litigated as a class. I think these claims fall into a few buckets, and the first one we'll talk about is what I think of as the first wave suits that really arise out of the virus itself, so that people who have been either exposed to or contracted the virus as a result of what they believe is the conduct of other businesses. And one of the or set of the class actions that we've been seeing are arising out of the travel industry, particularly on cruise ships. And we've seen cases where there are several class actions arising alleging that cruise lines exposed their passengers to the virus as the result of negligent conduct by the cruise lines. there may be more of those types of cases coming, or they might arise in other aspects of the travel industry. But I think as we flatten the curve, we should expect not to see significant numbers of those kinds of first wave injury cases. But in the shorter term, of course, as we learn more about exposure and transmission, and learn more about the risks associated to failure to physically distance or things like that, we might see these claims arising out of areas that we're not thinking about right now. One of the places, and this goes back to what Matt was talking about initially, about the business closures and state-related closures, is that when businesses make a decision to operate, who would otherwise be closed, for example, there are some states that permit a business to seek an exemption or a waiver from a closure. When a business makes that determination, one of the things that it has to be thinking about is what is the potential exposure it has accepted or created by deciding to continue to operate. When a plaintiff or a group of plaintiffs can make a claim that the business knew or should have known that it should not have been operating given the government shutdown. And what we'll see and what we continue to see is that these class actions are arising not only with businesses that continue to operate, but businesses that decide not to operate in response to the pandemic. And that's probably that second large bucket of claims that we're seeing are those class actions that are arising out of decisions by businesses or organizations not to operate in light of the pandemic, or to change the manner in which they operate. And so everyone probably has seen in the press, one of the groups of organizations that was at the forefront of some of the closure issues were many of our higher education institutions across the country, colleges and universities across the country. And what we're seeing is claims against those colleges and universities who are operating remotely, claims either for tuition, people saying that the remote operation is essentially not what they bought, not what their tuition paid for, and they should be refunded for the tuition, or claims related to room and board or other related fees. So that and those are showing up in a couple of different places. And obviously, while a college is or university is able to talk about in those cases the context of providing remote learning and what that means, there may be trickier issues around things like room or board. And we have that at the one side. So the colleges and universities that decided to close and the claims that arise against them. Not all colleges and universities closed, and in fact, just yesterday, there was a new class action filed against a university that opted to continue to operate, and claims that the students are at risk because of that decision. So there is a little bit of either decision to operate or not to operate has its own risks attached to it, and certainly owns its own litigation risks. It's possible in those contexts that we'll start to see more claims against colleges and universities coming, but most of that, at least for the spring 2020 semester or term, has already happened. So those facts are already in place. If people are suing, they probably have already sued. What I think we'll all be looking for and keeping our eyes open on is how do those organizations respond in the summer or the fall, depending on where we are with resolving the pandemic. That issue, though, is not limited to colleges and universities, and we're seeing a series of other claims arising against businesses that have made determinations about how best to respond due to their inability to provide goods or services as a result either of a government-ordered closure or just the existence of the pandemic itself. And so there's one of the places, not surprisingly, is in the travel industry. And as I mentioned, there were that first wave injury claims against cruise lines. What we're also seeing now is litigation against various businesses in the travel industry regarding refund claims. And so travel, either it's plane travel, cruise travel, event travel, hotel travel, is canceled because of either a government shutdown or just a concern about COVID-19 itself. And how does the business respond to that? And what is the business's existing policy regarding refunds? And so there's litigation against airlines now, and I expect we'll start to see more against hotels to the extent it exists, where the airlines have exercised what they see as their option to provide credits to people for canceled travel. And the argument is that in fact they should be required to provide refunds. And some of the arguments are going to revolve around whether those cancellation policies, even if we assume the business is acting on its own cancellation policy, whether there is something about this current crisis that renders those types of refund policies or those types of credit policies unenforceable, that they become unconscionable is the argument that is being made. So one thing that businesses can be doing as they are heading into these decisions or making these decisions is thinking about not only what does my contract actually permit me to do based on its plain words, but is there some overlay from the current crisis that would cause those particular written provisions to be modified or perhaps even unenforceable in some ways. Not surprisingly, we're starting to see some other claims related to the economics of this. We're starting to see 10b-5 claims showing up, and there are claims related to data privacy, of course, and we've seen one already, and are probably going to see more claims as life sciences companies in particular get involved in the process of developing vaccines or testing for the virus, and it's both to detect it and to treat it, that representations made in securities filings are going to be scrutinized for how accurate they turn out to be, and whether there is any aspect of them that might be deemed or be seen to be false or misleading, and we can certainly expect to see some of those claims. But those are sort of the first wave injury claims, and maybe what we can think of as the second wave response claims. The third wave of claims is what's coming in the future, which are the reopening claims. The good piece, if there is one in this, or maybe the bright light that exists, is I think most of us believe this is going to end. And we may be shaped and altered by this, and there's no question there'll be substantial loss and damage as a result of it, but this will end. And we are going to go back to business as usual in some ways, although undoubtedly it changed, and hopefully we've learned stuff from this. But when that happens, and when these government restrictions start to get lifted, and when we reopen the economy, individual businesses are going to have to make determinations about whether to open, how to open, what opening looks like. And we can expect certainly claims to the extent, God forbid, that businesses open and there is a spike in additional cases of the virus. We can expect a repeat of the sort of first round of claims, the first virus-related claims, that the business opened too early. It won't surprise me at all that if there's a more cautious business that is unable to provide services because it decides to postpone its opening, that we will see claims from perhaps suppliers or business partners that the failure of the business to open when it could do so is a violation of a contractual obligation or somehow creates additional liability. So there are a lot of minds in this field, and I think that as we work our way through this and come out of it, businesses are going to be needing to think through the implications of almost every decision to minimize the risk of these kinds of claims going forward.
Thanks, Brian. Obviously, a lot to monitor in the coming months. So let me pose a question to the broader group. What are some of the important risk mitigation steps that businesses can take now? Matt, let me start with you.
Obviously, we've been talking about the potential for litigation. So as every litigator, would advise their clients, you got to document every step you took, all your policies, procedures, dates, when you took action. Make sure you have a really solid paper trail of the steps you took to either comply with governmental regulations, CDC, OSHA requirements, and really just have a robust file so that way, if and when litigation happens, unfortunately, you have the ability to easily explain and defend the positions that were taken.
Thanks, Matt. Will, what would you add to what Matt just said?
Yeah, I would definitely strongly agree with Matt, and I'd add actually on another topic that Matt spoke to about the exemption orders, that every state is at least slightly different, and those differences are material, so that any company that's operating in multiple jurisdictions should be clear that they need to be following the rules in each specific jurisdiction, and that if it's a close call, the advice we typically give is follow the most restrictive reading of the orders and take advantage of the exemption procedures, which all of the stay-at-home orders either have explicitly stated within the orders themselves or provide elsewhere, usually on websites, a process for doing so. And related there too, with all those exemption orders, they are not a pass to stay open and not follow the rules. They are, you can stay open if you follow the following rules. And they, the different jurisdictions have varied on how specific they should be. But some of them, like California, are extremely specific and even industry specific on what processes and guidances the businesses must follow. So the businesses really have to pay attention to the rules in the individual jurisdictions in which they operate.
Brian, how would you advise your clients in terms of the risk mitigation steps that they should be taking now?
So one of the things about this is we know litigation is coming, and often litigators, or the first time someone with litigation experience gets involved is after a complaint has been filed or after a demand letter has been received. And sometimes that's the first time a business recognizes that litigation is coming. That's just not true here. We know it's coming. And so I think having people whose skill set is to be able to assess that kind of litigation risk early, involved in the decision-making process now, might give businesses an opportunity to minimize some of that litigation risk going forward.
Great, thanks, Brian. And thank you, Matt, Ashley, Brian, and Will, for offering your insights today. If anyone has any further questions, please feel free to contact any one of us or visit our COVID-19 Resource Center at covid19.pepperlaw.com. Thank you.